Tēnā koutou katoa, no mai, haere mai. Welcome to webinar 4 about empowering secondary legislation. This is covered by chapters 14 and 15 of the legislation guidelines. Let me introduce myself. I'm Guy Beatson, Deputy LDAC Chair and a non-public service member of the committee and General Manager, Governance Leadership Centre at the New Zealand Institute of Directors. There are 3 parts to today's webinar. We'll start with a short introduction to LDAC in today's webinar. We'll then have a panel Q&A, and we'll introduce the panel shortly. And finally, we'll open up to your questions as a conclusion for the webinar. Let's start first with a brief introduction to LDAC and its role. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It has a mixture of public service and non-public service members. All members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer. Parliamentary Council Office provides secretariat support, including advisors, to support the committee. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments, Crown entities, as well as academics, lawyers, barristers, and consultants. A broad range of skills and experience is important because good legislative design is multidisciplinary. It's not just about the law. LDAC has 3 functions. We publish and maintain the legislation guidelines and supplementary material. That's Government's Handbook for Good Legislative Design. The most recent edition was updated this year, but guidelines have a decades-long history and are direct successors to the LAC guidelines. We carry out education and engagement activities, like this session today, but also by department and by issue. Both these activities extend our reach beyond our advice functions. It's common to see submissions to select committees refer to the guidelines, and ministers are required to address consistency with the guidelines and cabinet papers for bills. Our advice functions applies at 2 different stages. The bulk of our advice work is prior to introduction when we advise departments that come to us. We also make submissions to select committees. We aim to support good lawmaking. We're guided by the guidelines and supplementary material, which we'll hear more about today. The guidelines are not about policy, they're about expression of policy in law. This means you will not find us giving an opinion on policy. It's important to remember that the guidelines are just that, guidelines. These are not rules that must be followed. Our goal is to ensure that conscious design choices are being made. Whoops. Today, the focus of our webinar is on chapters 14 and 15 of the legislation guidelines on secondary legislation. We'll start with the purposes for enabling the use of secondary legislation powers. We'll then move on to who should hold the powers in secondary legislation. And we'll finish off with the LDAC supplementary material on confirmable instruments. And we've found that there's more of those than we thought there were. Let's now turn to the panel who are going to help us with this topic today. First, can I ask Sarah to introduce herself, please?
Kia ora koutou. My name's Sarah Kirkin. I'm a Chief Advisor in the Policy Group at the Ministry of Justice, and I'm also Deputy Chair of LDAC.
And Kelly.
Thanks, Guy. Kia ora koutou katoa ahi ahi Māori, ko Kelly Hansen-White tēnei. I'm the Chief Advisor Regulatory Excellence at Mahi Haumaru Aotearoa, WorkSafe New Zealand. I've been a member of LDAC since 2018, and I bring a regulator's perspective to the mahi of the committee. I'm a non-lawyer, sometime policy professional with a strong interest in regulatory regime design, and particularly in how primary and secondary legislation work together to create the whole regime.
So I suspect what that means is we've got 2 bush lawyers and a real lawyer on the panel today. That's a good way to be. Hey, before we get underway, just a reminder for our audience today that you can ask questions at any time during the webinar using the Q&A button at the bottom of the screen. So let's talk now about the issues that are relevant to empowering secondary legislation. We'll start with Kelly. Do you want to tell us what secondary legislation is and why you delegate a power to create it?
Yeah, as we know, Guy, Parliament is the body with the overarching power to make law in this country. and it does that by enacting primary legislation, acts of parliament. But it's often not appropriate or possible for an act to include all the details necessary for it to have its intended effect. And it's also not feasible for Parliament to be directly involved in making decisions about every element of a regulatory regime. There just would never be enough house time for that. I like to conceptualise the relationship between primary and secondary legislation as where the Act sets up the broad architecture or the skeleton of a regime, the what, and then secondary legislation puts the meat on the bones, the how. And you can see how Parliament might not be best placed to work through all the details of the how. So it will often be necessary to include a provision in an Act that delegates the power to prescribe those necessary details to another person or body. It's often part of the executive. So we need to cover off some key terminology in this space. Any act that delegates a lawmaking power is known as an empowering act. And then the specific provision in the empowering act that contains the power we call the empowering provision. And the product of exercising that power is secondary legislation. Now, there's a whole number of different names used for secondary legislation that you'll have heard: delegated legislation, subordinate legislation, tertiary legislation, regulations, proclamations, order in council, bylaws, rules and codes. There's just mazillions of names. But they don't provide a principled way of distinguishing between different types of secondary legislation. But since the commencement of the Secondary Legislation Act and the Legislation Act, all instruments made under an Act, with a very few exceptions, are now secondary legislation. And an empowering act provision in an Act will state if an instrument will be secondary legislation. So once you've established that the power you're creating is legislative, and we'll cover that a bit later, the key questions to be worked through about secondary legislation are: what can be delegated, who should the lawmaking power be delegated to, and what safeguards should apply. And then there are a whole range of competing considerations that need to be balanced when determining what's appropriate to be delegated: legitimacy, durability, flexibility, certainty, predictability, and transparency. We'll cover all of this off as we continue with the webinar.
Yeah, it's certainly fair to say, Kelly, I've always been puzzled by all of these names. So thank you for unraveling that for us. And I guess we should probably thank the Secondary Legislation Act too.
Yeah.
But now we've got that sorted, perhaps Sarah, how do you know the decision-making you are delegating is legislative?
Yeah, that's not always as simple as you might think, Guy. Broadly, I think there are 4 types of powers. I'm actually going to talk about the power of 4 quite a lot in this webinar. Everything seems to come back to 4 for some reason. But there are 4 types of powers that you generally find in secondary legislation. A power could be legislative, and if it's legislative, it makes or alters the content of the law. It might be administrative, which is where you're applying the law to a particular case. It might be judicial, where in nature, so that's not necessarily it's in the courts, but you're really determining somebody's rights or obligations in a particular case. Or it could be a persuasive power, where you're looking to influence somebody's actions, but you're not looking to compel them to do something. Now, even there, those aren't they're not buckets with hard walls that you're dropping powers into. They're more like kind of grey areas with boundaries that can blur into each other. So there are some questions that you can ask yourself to help you determine which area you're working in. And again, there's 4 of them. You can ask yourself about the scope of the application of the power. So if the power only applies in relation to 1 or more named persons, or in a particular case, it's unlikely to be legislative. It's more likely to be administrative. You can ask yourself about the scope of the discretion that that's being applied. A narrow discretionary power is usually not legislative. It's more likely to be administrative. You can ask yourself about the nature of the power. So powers that regulate conduct for class of people where non-compliance would incur a sanction, that's generally going to be legislative. And lastly, you can ask yourself about what is the impact on the Empowering Act. So if your delegated legislation is going to change the scope of the Empowering Act, so it's acting like a Henry VIII clause, that's going to be legislative. Yeah, so there you go.
That's interesting, eh? And funny that we've got 4 types of powers and 4 considerations. I guess I was asking myself as you were saying that it does everything come in 4s. And I guess
does.
In that sense, we may never know the answer to that question, but I wonder if it would help our audience today if Kelly and then Sarah can give us a sense of the issues that are particularly relevant to secondary legislation.
Yeah, so Guy, there are different types of empowering provisions that permit varying functions, and I'm going to talk about 2 specific examples and then Sarah will take over from there. So commencement dates for primary legislation can be set by orders in council, so secondary legislation, but only if flexibility is needed for good reason. And if that is delegated, the need needs to be justified, and there should generally be a backstop commencement date in the primary legislation as a fail-safe. And legislation can also authorise incorporation by reference. So the Standards and Accreditation Act provides general authority for New Zealand standards to be incorporated by reference into secondary legislation, including bylaws and all those other names. And the Legislation Act provides the general authority for secondary legislation to incorporate by reference other types of material like international standards or other documents that aren't standards, and prescribes rules that apply when that general authority is relied on for publication and holding copies, etc. So what is incorporation by reference? It's when you create or define rights, powers, or obligations by referring in legislation to another document or a part of a document rather than setting them out in the legislation itself. And usually those documents are prepared by someone outside government. So in that way, incorporation by reference is to a certain extent inconsistent with the fundamental principles of good lawmaking. You know, material incorporated by reference is not required to be presented to the House of Representatives, published under the Legislation Act, but it can enable a host of benefits, starting with making the law shorter, simpler, more consistent. So in the main, incorporation by reference should be used only if there's a very strong need or benefit from doing so, or it's not practical to do it any other way. So an example might be where, you know, the material you want to refer to, or you want to make law is long or complex, it covers really technical matters and might only affect a small number of people. So that would lead you towards an incorporation by reference.
Yeah, it's interesting, isn't it? I mean, as you've been talking, I was recalling earlier in my career, actually, some issues that arose with Japanese used cars and trying to incorporate by reference the car manuals into rules and in the transport legislation or the transport regulations. And all of that was in Japanese. Yes, well, I think we've moved well and truly beyond that. I guess if I can turn to Sarah and just get your sense of the issues that are particularly relevant to secondary legislation.
Yeah, there's one that is of particular interest to me as a constitutional lawyer, and that's the Henry VIII clause. And this is one where you might have a provision, an empowering provision that says you can make a regulation that will change the primary statute. And you know, that can be problematic because your Parliament's effectively saying to the executive, look, you know, we've made this law, you the executive can go and change that law, you know, within certain parameters, but in any way you see fit. And that kind of power does need, because it poses more risk, it does need a strong justification, and it does need careful designing of safeguards, which we are going to get onto in a little bit. Now, we have seen a number of Henry VIII clauses over the last 10 or 12 years in New Zealand because we've had them used in our emergency legislation responding to the Canterbury and Kaikoura earthquakes, and also responding to the COVID pandemic. And they have been used quite carefully and very responsibly to allow a flexible response to an emerging situation where the precise nature of the powers needed wasn't quite understood at the time that the initial legislation was made, and the executive didn't want to have to keep going back to Parliament every time it uncovered something else that it needed to do. But they do need scrutiny. So at the other end of the spectrum, you do get some Henry VIII clauses where they're simply wanting to adjust primary legislation in a very narrowly circumscribed way, where the adjustment doesn't actually change the policy or the scope of the primary legislation at all. And we've got a number of examples of that in the Privacy Act, where the Act allows a number of schedules to the Act to be amended by order in council. And those schedules set out approved information sharing agreements, information matching provisions, and agencies who can verify identity information and a few other things. And by order in council, the Ministry of Justice can add new approved agencies when they've done their information matching agreements. Those just get plopped into the schedule, and it saves going back to Parliament. But we get the transparency of having those all sitting there in primary legislation for everyone to see, and they don't have to go hunting to find who's got an information matching agreement.
Yeah, that's great, Sarah. I mean, it does illustrate just how powerful this is. And as you say, we'll come back to that safeguarding stuff. So thanks to both Kelly and Sarah for guiding us through those additional issues. I guess it's worth summing up what you've heard from both of you. And I'd note a few things. There are a number of reasons why decision-making powers are delegated. Secondary legislation is the only legislative means of delegation. And there are 3 other categories that cover non-legislative powers, as Sarah's talked about. It's important that the most appropriate powers used, and this will sometimes require careful analysis, in many cases, quite a lot of the time. Secondary legislation does have significant power and the ability to override primary legislation. Now, that depends a bit on the empowering provisions in the Primary Act, of course, but it's given that power, it's therefore essential that its nature is well understood and the frameworks around secondary legislation are used appropriately. So that concludes the first part of our webinar. I'm now going to turn to looking at the key considerations when thinking about the purposes for which the power to make secondary legislation may be exercised. So to kick us off on this topic, I'm going to turn to you, Sarah, and can you tell us what can be delegated to secondary legislation?
Thanks, Guy. I want to take us back to something that Kelly said right at the beginning, which is if you think about the primary legislation as the skeleton or framework, and the secondary legislation is the meat and the bones, or the how. So the matters of significant policy and principle should be in the Act, and then the matters of minor or technical matters of implementation and operation should be in the secondary legislation. So just to give you some examples to illustrate that, things like matters that significantly affect human rights, significant public powers like search and seizure or confiscation of property, granting or changing appeal rights. If you're going to vary the common law by, say, taking away a common law right, creating criminal offences, imposing penalties, authorising taxes, creating new public agencies, and then procedural matters if they effectively set the fundamental policy of a legislative scheme. Those are all things that should be in primary legislation. So that's in the Act of Parliament. Then some stuff that could go into your secondary legislation include the mechanics of implementing an act, like prescribing the fees, setting out the format and content of documents, lower level procedures, large lists or schedules of minor details, technically complex matters, commencement dates if you really need to and you have a backstop in the primary legislation, Subject matter that requires flexibility or updating in light of technological developments, but the caveat on that is if it's really, really central to your policy of the Act, it probably needs to go in the primary Act. And then material that requires input from experts or key stakeholders might be something that you might consider incorporating by reference. So that's where you've got, you know, the content is maybe best contained in a technical standard rather than in legislation. So just a couple of other points to acknowledge, to point out here. When you're creating that empowering provision, you do need to be clear about who's going to be making the delegated legislation, and then you need to be clear about how they're going to make it. So if it's going to be a regulation or an order in council, you can lean on the processes in the cabinet manual, but if it's something else, you're going to have to look at procedures that kind of emulate the procedures in the cabinet manual so that you get the protections from those procedures. You also need to think about how you're wording your empowering provision so that it's wide enough to give you all the power that you need to implement the Act effectively without being so wide that you can drive a truck through it. So Parliament has to know what they're authorising you to do, but you don't want to also confine yourself unnecessarily. You can't use an empowering provision, though, to fill gaps in an Act that have occurred because you just didn't have time to do all your policy work.
So I guess, Sarah, if you think about what you've talked about, if you were going to sort of say to our audience, what are the 4 things they should consider in terms of what can be delegated? What 4 things would you identify?
Right. So go back to the rule of 4. Your legal framework and your secondary legislation should be aiming to be legitimate. So you want people to trust your law and want to comply with it. It needs to be durable and flexible, so it can respond to changing circumstances. It needs to be certain and predictable, so people need to be able to work out how it's going to behave. And it needs to be transparent. If you have too many layers of secondary legislation, it can really make your framework fragmented and complex to navigate. So yeah, you know,
that's a great set of 4 things. So now we've kind of worked our way through what can be delegated. So thanks for getting us through all of that. Now we'd like to turn to Kelly, and we're going to talk about who exercises the delegated power and how you make that kind of decision.
Yeah, so there are no strict rules on who should hold the delegated power, Guy, but they should be appropriate, having regard to the importance of the issues at hand and the nature of the safeguards that are in place, because the whole system needs to work together as a whole in that way. So traditionally, secondary legislation is often made by the Governor-General and Council on advice of a minister, and we usually know these as regulations. And this ensures that a full set of safeguards are in place, and we'll talk about those further later. But secondary legislation powers could also be delegated to the relevant portfolio minister, to an official holding a particular role within a department, to a Crown entity that has the relevant technical expertise and accountability for the area of law, or occasionally an entity outside of the Crown could be delegated powers. So an example of this is the rules made under Section 67 of the Registered Architects Act, which are made by the New Zealand Registers Architects Board. Now, the entity is created by statute, but it's a body corporate separate from the Crown. So that's reasonably unusual, but it is possible. So overall, the key factors to consider in figuring out who should exercise these powers is what's the extent of the policy or the value judgments required? What's the expertise required? What kind of degree of political accountability is needed, and what safeguards would apply as a consequence of that person holding the power.
Yeah, and I guess we'll get to those safeguards shortly. But I guess from a personal point of view, you talked about working in a basically an entity that actually works under mostly secondary legislation. And so you've had quite a lot of experience operating in that secondary legislation world, if I can call it that, particularly recently. So do you have some insights that you've gained about the best practice in terms of who exercises those delegated powers?
Yeah, so we've got quite an interesting scenario under the Health and Safety at Work Act, Guy, in that we've got a special type of secondary legislation known as safe work instruments. We've got regulations as well that are made in the conventional way, as I've just talked about. But safe work instruments are for specifying really technical matters of detail underneath, for example, the regulations we have about how to work with hazardous substances safely. So they're not your general kind of reading material. And while WorkSafe's got the function of developing those instruments, the Act delegates our minister the power to approve them and make them into law, which he does on our recommendation. So, you know, we've got a slightly different sort of setup for those instruments. But because this was a new kind of instrument and it wasn't completely clear how the use would play out, the Act also provides our minister with the ability to further delegate that power of approval to WorkSafe if deemed appropriate, so that we could be in charge of the whole process ourselves. Now, to date, 6 years into the regime, that hasn't happened. But there would be appropriate safeguards in place regardless if it does, because the Empowering Act has set all of those up. So it's just a really interesting sort of case study, I guess, of how different things can be done to achieve different outcomes.
Yeah, and I guess we should emphasize, of course, that your experience with WorkSafe was one experience. There's a whole bunch of other regimes, and even what you've just said, there's kind of all sorts of words that describe what that secondary legislation is.
Yeah.
So I guess through the what and the who, we've made clear how much secondary legislation can be delegated from Parliament. And we've also made clear through the comments that both of you have made, I think, that there's quite a lot of power associated with the secondary legislation as well. So, we've talked about safeguards a little bit in each of the commentary that you've both provided, but I want to turn to Sarah now and just get you to articulate a bit more widely what safeguards you think are required to effectively manage the power we've just talked about.
Sure, thanks, Guy. I think the first point I want to make is that in New Zealand's constitution, the procedure is the protection. So I think that's really important to remember when you're thinking about safeguards. The other thing that's quite important to remember is that there are a number of protections that are kind of built in to the system if you're creating secondary legislation that's in the form of something that goes through cabinet, like regulations or an order in council, because you can lean on the cabinet manual, which has a whole bunch of procedural protections that are all around, consultation to make sure you're getting in a number of perspectives, which means you can iron out any fishhooks in your policy, and you're getting ministers' buy-in, and ultimately cabinet is collectively responsible for the policy, and they're accountable to Parliament for that. And then you've also got 3 safeguards that have been built in through the Legislation Act, and they are and they're also procedural. Their presentation to the House. So this is where secondary legislation is presented to the House by the minister, and that ensures ministers' accountability, and it's an essential part of ensuring that Parliament can scrutinise what's been done with the power it's delegated. Parliament can't scrutinise if Parliament doesn't know the regulation exists. There's also review by the Regs Review Committee, which is a really important committee in Parliament. It looks at all secondary legislation and can recommend that it be disallowed. And an inquiry by the Regs Review Committee is something to be taken seriously. We've had a couple of things go to the Regs Review Committee in the last 12 months, and it has resulted in us voluntarily redrafting some regulations to address an issue that the Regs Review Committee felt needed to be addressed. And then publication. which is, you know, if legislation's drafted by Parliamentary Council, it's published in full on the New Zealand legislation website. And if it's not drafted by Parliamentary Council, then whoever's made the legislation has to publish it in full and in accordance with the requirements of the Legislation Act. And what that means is people can find out about the law, which means they can apply, you know, they can comply with it. You can't comply with the law if you don't know it exists. And if you are dealing with secondary legislation that's, you know, not a regulation, not an order in council, so it doesn't have the procedural protections of the Cabinet Manual, yeah, you really do need to try and create proxies for those so that you're picking up the safeguards, because that's actually the protection that you're building in.
Yeah, so basically what you're saying, Sarah, is it's mostly all there in terms of the way the process works, but it's still worth thinking about. Although, having said that, as you were talking about the Regulations Review Committee and various of your colleagues' appearances before the Regulations Review Committee, I had flashbacks myself. So while I understand the importance of this, the experience is cathartic, shall we say.
It can be unnerving.
So useful protections. So we've had a useful discussion about the thinking we need to do about the purposes for which the power to make secondary legislation can be exercised. I've taken a few key points from both the comments from Kelly and Sarah, and I think I'd point to three of those. Overall, deciding who should hold the power is a process of careful analysis of the appropriateness and implications of the specific actor holding a power. Luckily, we've got a number of principles and guidelines to take into account when undertaking this analysis. And the same process, with adjusted considerations relevant to the specific context, is required when deciding what safeguards are appropriate. And picking up the point that Sarah's just made, actually, a lot of that's actually built into what we do. So I'm sure what you've heard so far will be raising a lot of questions for our panel today. Just a quick reminder, if you've got questions, please use the Q&A button at the bottom of your screen. We've got one, but I'm sure there's a whole bunch more. If you'd like to ask those, just go to the Q&A button. But before we get to those questions, let's turn to a potentially more obscure part of secondary legislation, confirmable instruments. To help us understand this a bit better, Kelly, can you explain what a confirmable instrument actually is?
Yeah, so this is something that not everyone will necessarily have come across, Guy, because it is a bit unusual. A confirmable instrument is secondary legislation that gets automatically revoked by a particular deadline unless it's been confirmed by an Act of Parliament. So the Empowering Act sets up that situation by identifying which secondary legislation under it is a confirmable instrument. Confirmable instruments are made under Schedule 4 of the Legislation Act 2019, and it works as an additional safeguard in cases where more parliamentary scrutiny is desirable. So it's the you know, we're giving you this power, but we kind of want to keep an eye on how it's going and make sure that it's not going awry, I guess. So in that way, the confirmation process should be applied sparingly and only where it's necessary or desirable to give particular types of instruments additional layers of parliamentary scrutiny. Because again, it is about house time and having the accountability sit where it really should fall. So confirmation by Act is usually, but not always, done by an annual subordinate legislation confirmation and validation bill.
Interesting, eh? And I'm sure I'd be interested to know whether any of our audience have come across these or are responsible for them. But I guess having heard what they are, and we now know a little bit more about this aspect of secondary legislation, Sarah, can you help us with when secondary legislation should be subject to confirmation?
Sure. Well, actually, helpfully, the Regs Review Committee in the last Parliament did an inquiry into this and made a number of regulations, which the current Regs Review Committee has picked up and is continuing. And essentially the thinking is that confirmation processes may be necessary or desirable for secondary legislation that includes emergency regulations. So I think the thinking there is that there's probably a lot of power being delegated with possibly little, blurry boundaries. Secondary legislation imposing a financial charge in the nature of a tax. Secondary legislation that amends the Empowering Act or another act or act. So there's your Henry VIII clause. And secondary legislation on issues of policy under broad empowering provisions. And again, that's, you know, there's the scope of the delegations not clear. And so Parliament just wants the ability to really keep an eye on how that's being used. So there are also, helpfully, some examples where confirmation processes may not be appropriate. If the secondary legislation isn't going to, there's not much discretion involved in the substance of it. So if it's just, you know, the substance is all settled and it's very mechanical in nature, not much point in confirmation. If the secondary legislation is going to be subject to a sunset clause or will be automatically revoked within the confirmation timeframe. If it's a Henry VIII power, but that power is not going to affect the scope of another act. So that thinking about the Privacy Act examples I gave before, it's not really affecting scope. So potentially doesn't need to be subject to confirmation. If the secondary legislation is going to incorporate into New Zealand law international obligations that have already been subject to a treaty process in Parliament, and that's because Parliament's already had a chance to really look at it and think about the treaty itself. And if there are other significant safeguards on the exercise of the power that would render the parliamentary scrutiny largely redundant.
Yeah, it's interesting, eh? And I guess it's one of those things, as we've been talking about this, it's got me wondering, and I've never had any personal exposure to any of these confirmable instruments. I'm sure the people on the webinar today, those who have to be responsible for it, will be fully and truly aware of that. But I'm sure there's a bunch of the rest of us who aren't. I just wondered whether Kelly or Sarah, you've got some examples of these confirmable instruments.
I do. I had a little dig around on this matter, and I see there's an act that regulates petroleum demand restraint, and it allows for regulations to be made, which could, in effect, impose a fuel rationing scheme on the country, and that's a confirmable instrument. Because you can imagine why that would just not be something that Parliament would just want to hand over to the executive and not really have some sort of view on. So and other things would be where new activities are added to the Climate Change Response Act. So again, where another whole sector is being tasked with reducing or removing its emissions, that's got to be confirmed by an act of Parliament. So I think that, you know, once you look at it through that scale and scope lens, it kind of makes a bit of sense. And levies and, you know, excise levies, road user charges are other examples.
Hey, the other thing that springs to mind, particularly given the work that you and I have done on COVID-19 a few years ago now, a kind of bit of a puzzle in the sense that the COVID-19 legislation kind of looks like this. Is it the same?
It kind of, but not. So so when the COVID Public Health Response Act was put in place, because, you know, the situation was emerging really, you know, rapidly, and it is, you know, like Sarah's been talking about, in an emergency situation, very you know, unusual. That act kind of has a natural sort of death every 90 days unless it's reconfirmed by Parliament. So it's like it's somewhat like this, but it's just at that act level where the act has a limited lifetime unless it's continued to be needed and confirmed by Parliament. So it's just like a snooze button.
Yeah, so it's the same sort of concept, just the primary legislation, but that's not what we're talking about today. So I guess my takeaways from what you've both said are the following. Confirmable instruments are a useful safeguard, which sometimes could or sometimes should be applied to certain types of secondary legislation. Confirmable instruments are another tool used to support the rule of law in New Zealand. And importantly, and just in case people are looking for more guidance on all of this, LDAC has some very good information on our website. It's under supplementary material on confirmable instruments and associated links. Having said that, I guess there's also other useful links and information for everybody on the webinar today in terms of our guidelines and so on, and that's also on the webpage. So we've covered a lot of territory.